Good afternoon. This hearing will come to order. The Senate Committee on Indian Affairs was established for the primary purpose of representing the legislative and oversight priorities of Native Americans. The committee is the first stop in the Senate towards achieving these priorities and broadly fulfilling the United States' trust and treaty obligations. But Congress is capable of forgetting these obligations. Our trust and treaty obligations are not just abstract promises, they are enshrined in the United States Constitution, a constitutional mandate that committee members carry with them as they go about their work in the Senate. And when it comes to the Violence Against Women Act, Congress does not have the luxury of forgetting this mandate. That's because every member of this committee knows that public safety in Native communities is a problem. We've heard from tribal leaders, we've heard from law enforcement, and we've heard from the families of Native victims. Their message is consistent. Doing nothing is not an option. We've heard that message loud and clear in 2013 with the last VAWA reauthorization. Almost a decade ago, this committee came together on a bipartisan basis and voted to restore tribal criminal jurisdiction over non-Indians who commit domestic violence in Indian country. That vote, one of the first that I took as a new member of the Senate and of this committee, was Congress's first real step towards restoring justice for Native communities. Because before VAWA in 2013, when tribal law enforcement was called to the scene of a crime in Indian country, the officer had to figure out the nature of the crime, the status of the land where the crime occurred, whether the victim was an Indian, and whether the offender was an Indian. That meant tribal law enforcement officers, often the first responders on a crime scene, had to complete a complicated mental checklist before deciding whether to arrest or detain a suspect. It's no wonder tribes had their hands tied when it came to maintaining public safety on their own lands. And the criminals exploited this jurisdictional maze, preying on Native women and children and putting tribal communities in harm's way. But under VAWA 2013, tribes that opt to exercise special domestic violence criminal jurisdiction can cut through the legal red tape to enforce protection orders, and prosecute domestic violence crimes, all while safeguarding defendants' due process and constitutional rights. For nearly a decade, tribes have made at least 396 arrests for VAWA-related crimes and at least 133 subsequent convictions using special tribal jurisdiction. And despite the concerns of some, prior to the law passing, there have been zero valid habeas corpus petitions filed and zero claims of due process violation. So what we will hear today is a story of success. Each of our witnesses will underscore the importance of special jurisdiction for Indian country. They will also lay out ways that Congress can help tribes and Native communities build on this success in the next VAWA reauthorization, closing jurisdictional gaps, creating parity, providing resources, and making sure that Native Americans are not invisible in public safety data. These are just a few of the common sense bipartisan solutions that our committee can and should work to advance. That's one of the many reasons I'm thankful for my partnership with Vice Chair Murkowski. She has been an extraordinary leader for Native people across the country, in Indian country, of course in Alaska, on behalf of Native Hawaiians, and especially in this case, on behalf of people who are victims of domestic violence. And we will continue to work together to make sure Indian country priorities are included in the Senate's coming Violence Against Women Act reauthorization. Finally, before I turn to Vice Chair Murkowski, I'd like to extend a special welcome and thanks to our witnesses for joining us today, and I look forward to your testimony and our discussion. Vice Chair Murkowski.